Good afternoon, everyone.
Good afternoon, Judge.
Right, we ready to start? All right, ladies and gentlemen, I am Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrests, the Fulton County Solicitor General's Office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I'll be providing you with a reset date for SAP, and that date is, let's see, that date is 7/27/23, July 27th. I also want to remind everyone and advise you that this whole entire proceeding is being recorded as well as live streamed on YouTube. Govern yourselves accordingly. I want to remind the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to have representation or counsel at this proceeding. Most of you know who your attorneys are. I also want to remind you that you have a right to remain silent. Remember that anything that you state about the circumstances, the facts, or the occurrences of your case can and will be held against you. The state is here listening. Listen to your attorneys. All right, first case.
Collision number 9, Miss Jenkins.
Okay. This is 23 CR 00440D. Desiree Jenkins. You're charged with one count of willful obstruction of law enforcement officer. Pretrial.
Well, adult arrest. Resident of Florida. Last arrest 2022. Larceny conviction. She got FTAs from 2014, 15, and 16. 2014 grand theft, 2011 failure to appear. That's it.
All right, state.
Yes, Your Honor. This incident took place on July 13th of 2023, where officers responded to a suspicious person at 3802 Roswell Road. Upon arrivals, they met with the victim, Ms. Veronica Vasquez. And Ms. Vasquez basically said that she noticed a male with a shirt over his head looking through the window of her vehicle, pulling on her car door. Ms. Vasquez identified a individual in the parking lot standing by a white Camry. Officers then made contact with the defendant, and she actually told officers that the person who was going into the cars and looking into the cars was another individual by the name of Danny, which was a random individual and a random name, Your Honor. Later, she came to confess that it was actually Mr. Jared, which is the one who was actually going into the cars. Therefore, the state's recommendation is going to be a $2,000 surety bond and a stay away from 3802 Roswell Road.
All right. PD Wills.
Thank you, Judge, and good afternoon.
Good afternoon.
My client is 33 years old. She is currently unemployed until she will qualify to be represented by the Public Defender's Office. Regardless of what her friend, colleague was doing, she has only been charged with obstruction. For those reasons, I would request a signature bond for Ms. Jenkins, and if Your Honor is not so inclined, I would ask for a $500 surety bond. Thank you.
Okay. I'm going to order a $1,000 surety bond. With that $1,000 surety bond, and stay away from 3802 Roswell Road. No drugs, alcohol, weapons, or guns while on bond. And I did not hear anything as far as contact with the victim.
So yes, Your Honor, we would ask for a no further contact with Ms. Veronica Vasquez.
All right, and no further contact with Veronica Vasquez. That should conclude the ruling.
Thank you, Your Honor.
All right, thank you.
All right, we got number one, Mr. Bradley.
Okay.
And he has refused representation by counsel.
All right. This is 23 CR 004409G. Richard Bradley.
I'm sorry. Can you repeat that?
Who's speaking? Mr. Bradley?
I am now, Your Honor.
All right, can you, you're not speaking?
I
That
am.
wasn't him. at
Oh,
first.
that wasn't him.
No.
Okay. All right, you charge of one count of simple battery, family violence, second count of willful obstruction of a law enforcement officer, third count of criminal trespass, pretrial.
Fourth arrest, last arrest was last month. Death by taking in out of South Fulton. Before that was 1999 larceny conviction. That's it.
Your Honor,
I'm sorry.
I don't understand the charges. You said something about trespass. I wasn't made aware of that.
Criminal trespass. I don't know if the charge was added by the state once they accused the case or not, but I do have 3 charges.
Can you repeat those 3, please?
Simple battery, family violence, willful obstruction, a law enforcement officer, and criminal trespass. All right, go ahead, state.
Judge, good afternoon. My name is Brian Pilon. I'm presenting for the state. Officers responded to the location at 1:30 a.m. yesterday morning, so about 36 hours ago. The victim in this case told officers that she and the defendant got into a physical altercation. It was initiated by the defendant attempting to take her phone. The defendant eventually did take her phone and ran into the wood line behind their home. When the defendant returned to the home, he re-entered the home against the officer's command, then refused to come out of the home when the officers commanded such and barricaded the door with a washing machine. My understanding is the victim is present on Zoom. She alleges that the defendant has been abusive over the course of their marriage. She does not want further contact and does not want him in the marital home. Just to clarify, Judge, the criminal trespass charge comes from the taking of the phone. It is not theft by taking because they are married, but it's criminal trespass because he interferes with her possession and use of the phone.
What's the victim's name?
Victim's name is Miss Anisha Bradley. And I do see her on the call.
So you want there to be, your recommendation is for no further contact. What about a stay away?
Judge, our bond recommendation is a $3,000 surety bond with FVIP, no further contact with Miss Anisha Bradley, and stay away from the address, which I have here is 862 Cascade Crossing Southeast, and that's in South Fulton.
All right. Miss Bradley, Anisha Bradley.
Yes, ma'am.
All right. Do you wish to make a statement to the court today?
Yes, I had a question as far as support for the children, like grocery.
No. This is a bond hearing.
Oh,
Now,
okay.
Can't do any, all this is a bond hearing. And my question is, did you want to make a statement to the court? Tell me yes or no for that first.
No, I don't.
Okay. All right. So you can continue to listen and mute yourself. And all I'm going to rule on today is bond. Okay. Anything beyond that, you'll have to go to a different forum for that. Okay.
Okay, yes, ma'am.
All right. Go ahead. Who's representing Mr. Bradley?
Pro se, Your Honor.
Oh, I'm sorry. She did tell me that. So you're representing yourself. You understand the consequences of representing yourself?
Yes, ma'am.
Okay, so if you make any statements against your interests, they will be used against you later I don't recommend you represent yourself. This is a serious criminal proceeding. But if you wish to go ahead with that being the case, I will listen very briefly to you because I'm sure it's going to be interesting. So what is it that you would like to tell the court?
First, I'll be pleading not guilty to all charges. I know we can't get into the details of it, so I won't discuss the details other than to say I never made physical contact or skin contact when I slid the phone out of her back pocket. And then I did not leave the property. The statement's incorrect that I ran into a wood line and I left. I ran into my own backyard where my chicken coop is, and that's where I was. So the phone never left the property. I did not deny the defendant, the complainant use of her phone. I was just trying to go in her phone because she came home intoxicated at the hour that the state mentioned.
Okay, I'm not going to debate the facts with you.
Okay.
Because the warrants have already been taken out. The case has already been accused. So
Right.
how old are you?
I am 43 years old. I'm active duty military. I work in the Sam Nunn Federal Building downtown. I have 8 children. I know she's concerned about groceries. I take care of, my oldest 3 are in college. 2 of them live at home. We have 5 minor children at home. I'm very actively involved in their lives. I don't know what my life will look like if I'm not allowed to come back home. There's no history, even though the state said that there's a history of violence, there is no history of domestic violence. This is all a lie. My wife is trying to take custody of the kids. We're getting ready to go through a divorce. This is a very great effort that she has launched to try and discredit me. I would ask, I'm not a flight risk. I'm a federal employee. I'm active duty military. I really don't have a lot of money because I have 8 children who depend on me. My wife pays 0 bills, even though she has a job. Her money is hers, but I pay 100% of everything. Rent alone is $3,000. And if I can't return to that home, I don't know where I'm going. But I assure you that I will come to whatever, I want to get this resolved. This has very big implications for me with a top secret security clearance in the military as a federal employee. This must get resolved. Like I will show up in court. I do not need a bond. If you would release me on a signature, that would be great, Your Honor.
Right?
Me and her both know and I don't know yet. That's why I gotta wait and see.
Your Honor, I'm having a hard time hearing because there's someone else in the background, but I just wanted to make you aware of just some basic information about the posture of this situation. So the report indicates, and our review indicates, that this married couple intends on filing for divorce, but there has been no filing. There's no actual divorce that's pending or ongoing, no representation that has occurred. They're currently living in the marital home. And the prior instances that we have been told about basically include gathering information and evidence to try to use against each other in some divorce that may happen in the future. So Mr. Bradley had a theft by taking case that was ultimately dismissed based on Judge Law's reading of the law, which she believes says you can't be charged with theft of a piece of marital property. That's why this gentleman's not charged with theft today. He's charged with the interference of the same type of property. But a month ago, it was the same allegation, stealing someone's phone that he happens to be married to, although a phone is usually for someone's exclusive use, like a vehicle, and marital property can certainly be taken and possessed by someone who is not the intended possessor. But that'll be a later date issue for a jury and demurrers potentially. So what we have here is admissions by this gentleman that when he was found hiding under his wife's bed, that he hid under her bed, that he went through her things, that he was intending on having her phone, and he wanted to take her phone so that he could go through it and collect evidence of what he thought was her cheating for some divorce later in the future. So at this point, what it appears to be is that 2 people living in a rented marital home who have not filed a divorce, but are currently having a difficult time living under the same roof and behaving in an appropriate manner. The police report does indicate children were on scene, adults and minor children. And erroneously, these people were told that they could not take a statement from a minor child, which is not true in a criminal matter. So although a situation like this would usually be one where we would want witnesses' statements about what was going on, that wasn't allowed to happen in this situation. Whether or not Mr. Bradley is employed by the military or who pays rent and whose money goes to pay bills, those are not factors to consider in bond at this point, but ongoing abuse, a escalating situation, which is what I would describe this as, and admissions by a defendant that he hid under the bed and purposefully was trying to go through the things of his wife to gather evidence against her, lets us know as the state that this is a situation where people need to be separated. And there needs to be an actual cooling off period. So we would specifically request for staying away from the location and no further contact, and for these people to go ahead and file divorce if that's the intention. This is a unsustainable situation to be handled in this manner. Thank you.
All right. Hold on 1 second. Has victim witness advocate spoken to Ms. Bradley?
Absolutely, Your Honor.
Hold on 1 second. I'm looking at something. Mhm. All right, I'm going to enter the $3,000 surety bond. I'm going to order that the defendant would stay away from the marital home. There has not been the ample cooling off period. I don't even think it's been 24 hours yet. That is to make sure that the victim and the children are safe and will be safe going forward. I will allow a one-time law enforcement escort to return back to the property with Mr. Bradley to get any personal belongings that he might need. I will also order no further contact with his wife, Anisha Bradley, at this point. If there's visitation allowed with the children, then that should be precipitated, or a third party should be the intermediary with that, for the minor children anyway. So find a third party that can help facilitate visitation. No drugs, no alcohol, no weapons, no guns while on bond. And that will be the order of the court at this time.
Judge, can you please give a breakdown of the bond?
State, what was your recommended breakdown?
Judge, I didn't suggest one, but I'd suggest 3,000 on the simple battery family violence.
Okay, well, I've only, the three charges, so I'll do $2,000 on the simple battery and $500 on the other two.
That's
For a total
acceptable.
of-
Thank you, Judge.
Okay, for a total of $3,000. All right, that'll conclude this matter.
All right, next we have number 2, Mr. Bullock.
23 CR 0044110Y. Anthony Bullitt, charged with 1 count of criminal trespass, pretrial.
17 total. Last was 2015 for a capital offense. It was not presented to a grand jury. Before that was 06 simple assault, battery dismissed. Everything else is old.
Okay. State.
Judge, in this case, officers responded to the location 1481 Venetian Drive. They met with the victim, who is the property owner, who advised the defendant had been previously trespassed from the property last year and had moved back into the property. The victim was able to show the officers paperwork with the eviction order that the marshals had come and escorted the defendant out, and that he had moved back in. So officers placed the defendant in custody. Our recommendation is to maintain the $2,500 surety bond that's already in place, to add a no further contact order with Saman Tom, and to stay away from the location. Just, I will just note, he has 9 cycles in Georgia. Pretrial is correct that a lot of those are old, but the 2015 capital offense arrest is concerning. And there are also some 2016 charges involving animals that caused harm to citizens.
All right, PD Wills.
Thank you, Judge. My client is 54 years old. He is a native of Atlanta. He is currently unemployed and will qualify to be represented by the Public Defender's Office. He is currently a student at the Ultimate Medical Academy, where he is studying medical billing and coding. My client does understand that he cannot be at the premises, that he must vacate the premises, and that he will not return there. He has alternative housing. He will be living with his sister. We have no objection, of course, to no further contact with the property owner. My client absolutely cannot afford the $2,500 bond. And as it was stated, his offenses are old. He tells me that the capital offense is actually his brother. He has a twin brother, and there was some mix up with his paperwork. I haven't had the opportunity to research that, but at any rate, that's not, he hasn't been found guilty, or those charges haven't moved forward, and that is from 2015. So for all of those reasons, I would ask for a signature bond. And if your honor is not so inclined, I would ask that his bond be set at $500 for the criminal trespass.
All right, I'm going to order the $500 surety bond. I'm going to order stay away from 1481 Venetian Drive. No drugs, alcohol, weapons, or guns while on bond. No further contact with, I don't know if it was Simon Tom or Simone Tom. Whoever the victim is in this case, no further contact. No drugs, alcohol, guns, or weapons while on bond.
Thank you, Judge.
I know he got a dormant bench warrant, right?
Does he?
He's got multiple
Out of Judge
bench
E.
warrants on cases.
Yeah.
So I see 1, 2, 3, 4, 5, at least 6 active state court cases are open related to dogs, reckless conduct, failure to quarantine.
So he got to go in front of Judge E. That stuff, I'm assuming. Unless they do the SAP.
Okay. All right, thank you. Next, Deputy.
Number 4, Mr. Green.
Okay. This is 23 CR 004404F. This is Robert Green, charged with 1 count of simple battery. Retrial.
12 total. Last was 2021 failure to appear. 2016 probation, 2014 battery DV, NOD. 2009 ag assault, robbery, obstruction, theft by taking, first offender. That's all one arrest. That's it.
All right.
Yes, Your Honor. So this incident took place back on July 12th of 2023, where officers were dispatched to 752 Cooper Street for a disturbance between 2 roommates. The report states that the defendant struck the victim, Mr. Jaden Lane, with an open and closed fist after a verbal dispute. Therefore, the state's bond recommendation, given this defendant's criminal history, his FTA from 2021, the battery family violence arrest. Therefore, our recommendation is going to be a $3,000 surety bond and a stay away from 752 Cooper Street and no further contact with the victim.
All right.
Good afternoon, Your Honor.
Good afternoon, Ms. McLeod.
My client is 33 years old. I noticed the state did not mention that the alleged victim, Mr. Lane, was arrested. I think that is significant, Your Honor. Mr. Lane and his friend actually were the ones who attacked my client. We need some background in this case, Your Honor. My client lives at this house. He lives there with his wife. Mr. Lane is someone that they rent a room to in their home. Mr. Lane actually assaulted my client's wife, and he swung, and they have video of him swinging at my client's wife. And this was when my client intervened to stop him from hurting his wife. Mr. Lane had a friend there who I believe was also arrested, who had a gun. He brought a gun into this man's house and was brandishing a gun in front of my client's wife. Naturally, like any man would, he tried to protect his wife. He stepped in front of his wife. And this is when he had to try to restrain the alleged victim, who was also arrested, Your Honor. I would ask the court to consider giving my client a signature bond so he can get out of jail and get back to his wife and to his home, and to ask that the alleged victim does not come back to that location. My client is open to a one-time police escort for Mr. Lane to retrieve his belongings from that location. Nothing further, Your Honor.
Mm-hmm.
Your Honor, we would ask until the defendant is able to show proof that that is his property. So once he goes back, if he has some proof that that's his property, we of course will have a conversation with the victim in this particular case and let him know if the judge rules that he needs to evacuate. As the court is aware, there is a eviction process that will need to take place legally. So we just can't put him out tomorrow. So that's it from the state, Your Honor.
Well, Your Honor, we have a different position on this. This is a situation where this man was trying to defend his family, his wife. And the alleged victim was also arrested. It's not like the alleged victim was somebody who was innocently there. And he was there and he brought someone else who does not live there to brandish a gun in my client's home. My client and his wife are the lessors. They are the leaseholders in this property. And they, of course, made a poor judgment when they decided to rent a room in their home to this person. But if anybody should leave, given the fact that the alleged victim was also arrested, it should be the alleged victim, since this is my client's home.
If we might just have a moment, could we push this case further on the calendar so that we can review? All we have in this situation is warrants. And so we'll need to look up the information about a prior arrest of other people in the home. We just don't have the full picture, Ms. McLeod. And so I appreciate it.
Okay. Thank you.
All right.
Judge Macy, On
Yes.
yesterday, Mr. Lane was in the C calendar on yesterday, and Judge Law issued him a $1,500 good bond and no further contact with Robert Green and stay away from the 752 Cooper Street.
Thank you.
Yeah, Your Honor, I guess the challenge is that the warrant does not go into as much detail as Ms. McLeod stated on the record. So this is our first time hearing those facts about defending the wife and someone pulled out a gun and things like that. So that's why Ms. Allen asked for some more time so that we can kind of verify those facts.
Okay. So we'll move it to the end of the calendar today. Okay. All right. We'll hold. Next case, deputy.
Number 5, Mr. Griffin.
'23 CR 004405H, Yvonne Griffin, charged with 1 count of simple battery family violence pretrial.
Griffith, second arrest. Last was back in 2007. Carrying a concealed weapon, carrying a pistol without a license, possession of a pistol under 18 years of age.
Okay.
That's it.
State.
Yes, Your Honor. So this incident occurred back on April 19th of 2023, where officers were dispatched to 3725 Princeton Lake Parkways regarding a domestic dispute. Upon arrival, officers came in contact with the victim, Ms. Anita Blake. Ms. Blake advised officers that she was assaulted by the father of her daughter, the defendant. She said that they were arguing inside of the apartment, and the defendant slapped her on the left side of her face with an open hand. Officers did observe a small bruise on her left forearm, and Your Honor, the defendant fled the scene. Your Honor, the victim and the defendant are no longer in a relationship, but they do share one child, as mentioned. The victim no longer lives at the incident location, so the state will not be requesting a stay away. The victim did confirm the events in the warrant. The victim did state that she is not in fear. However, given the fact that there was a minor child at the place, and the defendant did slap her, the victim did confirm the events in the warrant, the state is going to request a $3,000 surety bond and no further contact with Ms. Anita Blake, and at the appropriate time, if the court can sound for her.
All right, Ms. Anita Blake.
Also, Your Honor, I'm sorry, I just want to put on the record that the victim also did file a TPO against the defendant. That TPO is 2023 CV382121. And it is active.
All right. PD Wills.
My client is 32 years old. As it was stated, he has very minimal criminal history, practically none. He is employed. He has several jobs. He works for Amazon, DoorDash. He's also a traveling vendor. He will not qualify to be represented by the Public Defender's Office. He has a high school diploma, and he plans to enroll in college courses next spring. He has one child, a 3-month-old, who he shares with the alleged victim in this case. I do want to note that this incident did occur back in April. My client states that the alleged victim was upset. She accused my client of cheating. An argument pursued. My client states that she is always angry and upset. She was living with him for a period of time, and he was actually on the verge or threatened with being evicted, possibly because of her behavior. He states that on the date of this occurrence, they were arguing. She got upset. She mushed him in the face. He mushed her back. That's basically the extent of it. But she did carry on. There are several witnesses who have witnessed her on that day and on other occasions carrying on loudly, yelling at the defendant. They can hear her screaming at him constantly. My client states that in addition, after my client after the verbal agreement or disagreement, the alleged victim told my client that he would never see his daughter again. My client did suffer injuries as a result of her physical contact with him. He suffered injuries to his back, his head, his torso. And she's also been physical with him on an occasion after this date. As it was stated, she no longer lives with my client. She has moved out. He has no desire to have contact with her. He has family members here who can facilitate third-party visitation. He's actually in a program that's going to help him legitimate his child. And so for all of those reasons, I would ask for a signature bond. Again, this incident happened 3 months ago. My client has not had any other issues with this young lady, and he just wishes to move on and live peacefully alone and away from her.
Your Honor, the state.
Your Honor, I'm here. Anita Blake is here.
Do you wish to address the court?
Yes, I do. So the altercation that occurred that
Ms. Blake, I have to see you to let you speak. You have to come to the camera and I'll swear you in first. So slow down a minute, hold on, and I'll come to you. So get your camera working first so I can see you, and then I'm gonna see what ASG Jones needs to tell me. Yes, sir.
Yes, Your Honor. I was just going to ask that you do not take into account any of the alleged allegations about her abusing him on this day and him having bruises. I think had he stayed at the scene when the police was called instead of fleeing, we would have been able to verify those things. But this defendant decided to leave from the scene. So we would just ask that you don't take that into consideration, as that is not a part of the warrant that was taken out for this particular case.
Your Honor, all of these are allegations at this time, and my client left because the situation had escalated to a point where he felt unsafe, so he chose to leave to de-escalate the situation. Ms. Blake attempted to prevent him from leaving and cause further injury to my client.
Okay. And Ms. Blake, where are you? You're at iPhone 3?
I'm right here. Yes.
Okay. We normally require you to put your name in there so we'll know who we have on the screen.
I'm sorry, I am at work, so.
Okay. All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Put your hand down. What are you going to tell me?
So that incident wasn't how he told his representation. Basically, I went to go get my other kids from my friend's house.
Hold on a second. Hold on a second. Hold on a second. And I'm sorry to interrupt you, but I'm not going to necessarily go through all the facts of the case. This is not your trial. This is not your hearing. This is a bond hearing. So I have 2 questions to ask you. Do you want to continue to have contact with Mr. Griffin? Did you hear me?
Yeah, we have a child together. I don't want a third party. Yes, can you hear me?
Okay, now I can. And are you in fear of Mr. Griffin?
No, I am not.
Any cross-examination by the state?
Just very briefly, Your Honor. Ms. Blake, you did call the police on this particular day, correct?
No, I did not. It was one of the neighbors when he proceeded to run out the door screaming at the top of his lungs.
Okay, thank you. The next thing is you did file for a TPO against the defendant after this event took place, correct?
There was a situation that occurred between us, and his sister stated that I should go ahead and file a temporary protective order.
Okay. No further questions, Your Honor.
All right.
I have a couple of questions. Ms. Blake, did you in fact file that TPO?
I beg your pardon, I can't hear you.
Is there a TPO in place between yourself and my client?
I did go ahead and file it, but we're supposed to I'm supposed to have a hearing on Friday, and I was gonna have asked them if they can drop it.
Okay, because you would like to have contact with Mr. Griffith, correct?
Due to us having a 3-month-old child, I feel like we should be able to coexist together for the sake of our 3-month-old without having a third party.
Okay, nothing further. I will renew my request for a signature bond, Your Honor. And again, my client does not desire to have any contact with Ms. Blake.
Your Honor, we would side on the side of them not having direct contact, third party contact, Your Honor. No further contact, and if there is contact, that it be from a third party, Your Honor.
We're in agreement.
Yes, we are completely.
Okay. All right, I'm going to order the $3,000 signature bond through the jail. I'm going to order stay away from 3725 Princeton Lake Parkway.
Oh, Your Honor, that is my client's address, and Ms. Blake is the one who vacated that property.
Ms. Blake, do you still reside at this property?
No, ma'am, I moved about 2.5 weeks ago.
Okay. All right, I'm sorry. I will take the stay away off, but there should be no further contact. Let's see, this was April. I'm sorry. No further violent contact between the parties. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And that's all I'm going to order. No further violent contact with the victim or the child.
Thank you, Judge.
Thank you,
Mhm.
Your Honor.
And next we have number 6, Mr. Griggs.
Okay. Hold for 1 second, please. All right, position 6, 23 CR 004406G, Derek Grisby, charge of 1 count of reckless conduct and a 2nd count of disorderly conduct. Pretrial.
What do we got? Third arrest. 2014 window tint. And a 06 simple battery dismissed. That's it.
State.
Yes, Your Honor. So this incident took place on July 12th of 2023, where officers responded to 789 Humphrey Street in regards to a shots fired call. Upon arrivals, officers were flagged down by the victim, Mr. Timon Daly, who stated that his neighbor stood up next to his gate threatening to hit his dogs if they did not stop barking. It was at that point that he fired a shot. Officers went to the home of the defendant and asked him to come outside. After several verbal commands, while screaming through his screen door, the defendant yelled, "Yes, I let off warning shots," because his neighbor fails to maintain his dogs and he believed they will jump the gate. Officers located 5 shell casings. The defendant finally came outside, yet he continued to make threats while outside. Officers arrested the defendant and found the firearm on his person that matched the shell casings that was found. For those purposes, the state is going to ask for a $10,000 surety bond, stay away from 789 Humphrey Street, and no further contact with the victim, Mr. Timon Daly.
That's the breakdown for the bond recommendation.
Yes, Your Honor. So it's going to be $8,000 on the reckless conduct and $2,000 on the disorderly conduct.
All right, PD Wills.
Thank you. So for starters, my client is the one who lives at 789 Humphrey Street Southwest. So that is his address. The alleged victim flagged down officers and they went to my client's home. So I would ask that he not have to stay away from where he lives. He is 39 years old. He is a native of Atlanta. There is a little bit of confusion as far as what his employment is. He states he works for the government. I requested a social worker visit to go out and speak with Mr. Grigsby to further assess. He states he has a bachelor's in communications from Georgia State University. Mr. Daly is his neighbor. My client just wants Mr. Daly to keep his dogs under control. I guess Mr. Daly has several dogs that try to jump over the fence and charge at, I guess, my client and maybe other people who reside in the neighborhood. My client was acting out of self-defense. And for all of those reasons, I would request a signature on bond. My client has very limited criminal history, and the history that I heard is very old. So I would like the court to take all of those factors in consideration.
Okay.
Your Honor, I would just like to briefly comment on the severity of a gun and firing it in the air. Bullets have no names and they have no place to land. So thankfully, the 5 shell casings that were found right now did not hit anyone. But you just can't go up to a gate and start firing warning shots, Your Honor. So again, we will ask that the court grant the $10,000 surety bond.
All right. I'm going to order a signature bond. I'm going to order that $10,000 signature bond through the jail. I'm going to order that to be $8,000 on the reckless, $2,000 on the disorderly. Stay away from 789 Humphrey Street. And no further contact with Timon Daly. And no drugs, alcohol, weapons, guns while on bond.
Yeah, Your Honor, my client lives at 789 Humphrey Street. That is his address. Law enforcement responded and they went to my client's home, not to Mr. Daly's home.
Okay, so no stay away. Okay.
Please.
If we can get some kind of a provision that keeps him from the gate or somewhere around there, Your Honor, some kind of protection for our victim and his dogs.
I believe that no further contact should suffice. I've explained to my client that he does not need to have any communication with them. And I know that he understands now he just needs to go in his home and not communicate or speak with Mr. Daly.
Well, Mr. Daly and or his dogs.
Okay.
He needs to make sure he's 200 yards from Mr. Daly.
Next, we got number 7, Mr. Hughley.
All right, Deputy, which case again?
Number 7.
Okay. 23 CR 004407Y. Rodriguez Hughley, charged with 1 count of simple battery, family violence, pretrial.
Second arrest, last arrest was for obstruction, possession of a pistol or revolver by a person under 18 years of age. He's out on pretrial bond for that. That's it.
All right.
Yes, Your Honor. So this incident took place on May 2nd of 2023, where officers responded to 3144 Martin Luther King Jr. Drive to an injured persons call. Upon arrival, officers were met with the victim, Miss Micaiah Driggles, and her first name is spelled Michiaah. Last name is spelled Driggles, Griggers, who advised officers that her baby's father assaulted her. Ms. Driggles said that she had just got home and the defendant met her at the front door and said, "You might as well put your stuff down because we are about to fight." As she continued to walk into the home, he punched her in the face in the presence of their 7-month-old son, knocking them to the ground and smashing her iPhone 11. She got away, locked herself in the bathroom to call the police, and he fled. Your Honor, for those reasons and given his criminal history, the state is going to ask for a $3,000 surety bond and a stay away from 3144 Martin Luther King Jr. Drive. I do believe that the victim is on, and if the court can sound for her at the appropriate time.
All right. The victim, do you want to make a statement to the court?
Yes, ma'am, I do.
All right. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Are you in fear of Mr. Hughley?
No, ma'am.
Okay. Do you want to have any contact with Mr. Hughley?
Yes, ma'am. We've already, since this incident, we have contact. We still do for our child, and there hasn't been any problems. And also some of the statement or what Mr. Jones said was untrue as well.
Okay. All right. PD Wills?
Well, if I could ask is it Driggers? I'm sorry.
Yes, ma'am. It's Micaiah Driggers. I don't know. I guess they spelled it wrong. I'll put the correct spelling if I need to, but.
So what exactly happened on May 2nd? You said that there were some things that were incorrect. What was
when I came home, we were both upset at each other. We did have words back and forth. It didn't get physical to where he said that he knocked me and my son down. I didn't even have my son. My son was in the house. Me and him were outside having a disagreement. My phone did break. He didn't intentionally break my phone, and I mean, I didn't have to lock myself in the bathroom. But
Okay. And all right. Thank you. Thank you. Your Honor, my client is 18 years old. He is a native of Atlanta. He is currently unemployed, but he was making a little bit of money doing odd jobs. He is still in high school and will be returning for his senior year. He has a 9-month-old child with Miss Driggers. He does deny the allegations. He also told me that there was a verbal disagreement. However, things never turned physical. My client states that his mom, as well as his sister, were present and were witness to the incidents that took place. And he also confirmed that there have been no other altercations, verbal or otherwise, since that date. Again, this incident happened over 2 months ago. My client is currently residing with Ms. Driggers and their child. They do co-parent, and my client does assist in the care of his child. I would request a signature on bond. And if Your Honor is not so inclined, I would ask that you give him the lowest bond that you're willing to give him in this simple battery case.
Your Honor, if I may briefly, while we don't want to cross-examine the witness, we do want to say that we understand that the witness is recanting. However, the witness did on this particular day tell officers that she was struck by by the defendant. She also called police on this particular day. In addition to that, the defendant did flee the scene. So since May 2nd, he has had an outstanding warrant. So he may be a fugitive for justice, Your Honor. For those reasons, we would ask that you keep the bond at the $3,000 surety bond and stay away from 3144 and no further contact with the victim.
And how old is the child?
The child is 9 months old.
And Mr. Hughley is how old at this point?
He is 18.
Still, well, 18. And he's already on a pretrial bond, correct?
3,500.
How much?
3,500.
Okay. All right, I'm going to order a $4,000 surety bond. And with that surety bond, I'm going to order a stay away from 3144 Martin Luther King Jr. Drive. No further contact with the victim. If there is to be visitation with the child, that be facilitated by a third party so that he won't violate the bond by having any contact with the victim.
Excuse me, ma'am, Judge.
I'm not finished with my ruling.
I'm sorry.
Also, there's to be no drugs, alcohol, weapons, or guns while on bond. And that's going to be the ruling of the court. Yes, ma'am. You had a question about the bond?
Yes, ma'am. Because you said if there was any I'm not in fear of him or anything. Like I said, we've had contact. We co-parent now. We're in the same household. We no longer stay at the 3144 address. But you said something about a third party as far as the visitation for our son. That's kind of hard for us because I'm getting myself together. I have my car. I just got my permit. I'm in the process of getting my car fixed. So there's I don't really have close family that's able to do a third party, or I would rather not do a third party because we've been doing well co-parenting. Even after the situation or whatever happened, we've been doing well co-parenting. And like I said, I'm not in fear of him. So I feel that we should be able to co-parent as we've been doing.
Well, there's been an incident. There's been police involvement, and there's been a case that's been accused and brought against Mr. Hughley, and I do understand you may have been co-parenting after this incident. But I want to make sure that you and your child will be safe. And I know it may be tough, but I want to make sure that there has been the ample cooling off period, or the fact that you and your baby will be safe. So he's already out on a pretrial bond that he's technically violated. So therefore, I'm not going to give him another chance on another signature bond to get out and violate that bond. So he's got the history that he's not showing himself to be credible to the court. So that is why I am ordering the $4,000 surety bond, and to give it a break and he stay away from you right now. He is to be 200 yards away from you. He did not contact you by any means, cell phone, email, social media. And I would order for him to take some anger management classes, but I won't order it today. That may be further down the road. And just want to make sure that for the future, you will be safe. So since you don't reside on the MLK, I guess there's no reason to have a stay away there. So what will be checked on this bond order will be the provisions where he needs to stay away from you. And those are pretty strict when you read the bond. And that if you're going to allow him to see the child, you're going to have to find a friend, neighbor, relative, or someone who can do that exchange, because if he violates the bond or he's found there with you, he will be returned to the Fulton County Jail.
Okay.
And that would be on a bond revocation because he's violated the terms again. So, use this time to reflect and cool off, get some help and counseling, and hopefully going forward in the future, it will be better. His attorney will know how to file for a bond modification if that is necessary in the future, okay? All right, thank you.
And Your Honor, this incident did occur over 2 months ago. Given my client's young age, is there any way you'd be willing to reduce his surety bond from the $4,000? He states that his mother is also experiencing financial hardships. So it's very unlikely that he'll have any assistance in being able to bond out. And that's a fairly high bond for a simple battery that occurred 2 months ago.
Well, it occurred 2 months ago, and then he's been on the run ever since, right?
I don't know about being on the run. He left he left the home. There is no requirement for him to stay. And I'm not sure whether or not he knew that he had a warrant, but I'm not sure that on the run will be an accurate description.
For the same reasons, I think
add something
arguing,
else?
hold on, Ms. Driggers. For the same reasons, I think arguing that something has happened 2 months ago is as easily disputable and not really relevant in this context. With domestic violence cases, women often call in crisis. And if someone is not arrested on the scene because they flee, it is often a delayed arrest. So saying that this isn't a big deal and it happened so long ago is kind of moot in this situation specifically. We don't know what happened in the time period, but what we have heard from this victim is that they have continued to have contact. They have moved to a new residence together, and she has now gone from being in crisis and asking for help from police to saying, we want to continue to co-parent together. So something has obviously changed, and that's something we would characterize as intimidation and continued domestic violence in a cycle.
There has been no evidence that there's been any intimidation or anything like that from my client perpetrated upon Ms. Driggers. Someone leaving an escalating situation is not necessarily evidence of fleeing, and there was no evidence presented that he fled. And I never said that this situation or domestic violence is not a big deal. I was just pointing out the fact that this did happen 2 months ago. They have continued to have contact and communication. There have been no other issues. He's very young and he does not have the familial support to help him bond out.
Well, the problem is pretrial. Are you revoking the $3,500 bond?
What you say, Judge?
Are you revoking the $3,500 bond?
Yes.
Okay. So he's going to have other issues, and I just want to make sure he understands how to conduct himself and how to be a good parent and a good significant other to the mother and respectful of her. His history alarms me, and I'm not going to change my ruling. The only thing I will change is to stay away if they don't reside at that location anymore. But I don't want him to have any further contact right now to make sure that they are going to be safe. Next case, deputy.
Number 8, Mr. Jackson.
Okay. 23 CR 004412J, Geronio Jackson, 1 count of battery, family violence, 2nd count of simple battery, family violence. Pre-trial?
I defer to the state. I don't have that file.
Oh, okay. State.
Yes, Your Honor. So we'll start with the facts of this particular incident. On July 12th of 2022 at 12:39 a.m., officers were dispatched to 1096 Fountain Drive for a dispute call. Upon arrivals, officer met with Miss Sierra Ketchup, who advised officers that when she arrived to her home, after asking the defendant not to return a couple of days prior, she noticed his car in the driveway. She then went in, opened the door, and saw the defendant inside the residence, and told officers that she believes he made entry through the window. The victim could not locate her items, and she believed they were inside the defendant's bag located in the car. So the victim went outside to the car to check the bag. This is when the defendant shoved the victim with the door. She tried to walk away to de-escalate the situation. He then came behind her and started choking her and threw her to the ground. He then fled. At the time, Miss Ketchup was 30 weeks pregnant. Your Honor, there's a probation violation from 2016. He has 2 FTAs from 2017 and 2023. He has a battery from 2020, which is 21 CR 00000. That's 5 consecutive zeros. 5J in front of Judge Betson, where he FTA'd on 6/23, so he has a open dormant bench warrant as well. And on this one, Judge Law gave him a $5,000 surety bond and no further contact with this same victim. However, as this incident proves, he has still had contact. Our victim witness advocate did have an opportunity to speak with the victim, and she still resides at the location. She did confirm the events in the warrant, and did confirm that she was pregnant at the time of the incident. And she stated that the defendant grabbed her by the neck with his forearm and slammed her to the ground. And then she stated they had an altercation about a month ago where she called the police and no arrest was made. The victim confirmed that the defendant has been violent with her in the past, i.e. that 21 CR case. Although she did state that she is not in fear of the defendant and still wishes to have contact, as Your Honor just heard about the cycle of domestic violence, and Your Honor heard about the open battery family violence case with the same exact victim. The state is going to ask for a $6,000 cash bond. Stay away from 1096 Fountain Drive. No further contact with Miss Sierra Ketchup, and if the court could sign for her at the appropriate time. And again, he also has a FTA bench warrant out of Judge Betson's courtroom for failure to appear on 6/21/23. Nothing else, Your Honor.
Excuse me, Judge. Sierra Ketchup is on live, but my video thing is disabled.
All right, when you signed in, you should have selected to sign in with video and audio. I see you now. So you
Hey,
got
Judge,
it, got
I
it
would
to
like
work.
to be sworn in, please.
Okay, all right, I will do that. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, are you in fear of Mr. Jackson?
No, ma'am.
All right, do you want to have contact with Mr. Jackson?
Yes, ma'am. We have 3 daughters together.
Mm-hmm.
But I did want to speak on what Mr. Jones just mentioned. In that report, Mr. Jackson do not have a car. That was his sister's car, and I was told that the back door was unlocked. Around that incident timing, I feel like I was the cause of the incident. I could have, because I had some of his possession, and that's what he was coming to the house for. But I had his possession, and when he went in the house to get the rest of his belongings, because his sister was outside waiting on him. I mean, I could have gave it to him, but all I just wanted my things, and that stuff kind of escalated.
Okay, well, I am not here to dispute some of the factual allegations with you. This is bond and to see whether he would be a good candidate for it and would return. He has an open FTA that concerns me that says he's not a good candidate for certainly not a signature bond. I want to make sure he's going to return back to court and not FTA again. How old are your daughters?
They're 3, 2, and we got a 9-month-old together.
Okay. All right. Any cross-examination? Ms. Ketchum?
You speaking to me, Judge?
No, I'm talking to the solicitor.
Ms. Ketchum, you did in fact call the police on this particular day, correct?
That night the incident happened, I called the ambulance, but for some reason, I guess they heard over the intercom that I was injured due to the fact of a male suspect. They showed up before the ambulance came.
Okay.
Took the report and then they left.
Okay. And you did in fact suffer some injuries on this particular day, correct?
Yes, they said that because the way I landed on my leg, I kind of like pulled the muscle in my knee, but nothing was broke. I was able to still walk.
Okay.
All right. PD Kim?
Yes.
Oh, I'm sorry, Mr. Jones.
Oh, no, that was it. I didn't know if she was still on. It looks like we may have lost her.
Oh, there she goes. PD Kim?
Oh, no, I was fine.
Okay. I just want to ask, do you don't live with him right now, do you?
No, ma'am. I stay with my mom, and last Wednesday that he stayed with was his sister. Came to the house to get his belongings at night.
Okay, and this incident this happened on July 12th, 2022, which is more than a year ago. Have you ever had any kind of contact with him after that?
Yes, I was constantly in contact with him. We do this together, and we do co-parent with him. Many kids.
And didn't you say that you went to court for 21 CR 50 and 5J? That case has been resolved? I think we lost her, Your Honor. But I would like to continue. Jackson is 30 years old.
Okay. We were having some technical difficulties, but we do need to move along.
Yes.
Ketchum. So go ahead, PD Kim.
Yes, Your Honor. He's 34 years old. He was working at SMI Recycling Company because he has 6 children to support. He lives with 3 of them with him. He's working as a machine operator. He works from 5 a.m. to like almost 10 hours per day, almost all week, Your Honor. And he was arrested last Thursday at Monroe, Georgia. And he has been in jail already for like 8 days, Your Honor. And he was transferred to Fulton County to face this charge. And I just wanted to consider that he has been in jail for about 8 or 9 days already. And because of that, he's almost certain that he lost his job. So he's going to be qualified for public defender services, Your Honor, and he's not going to be able to pay for any bond without his own employment, and he lost his job, and he has 6 children that he has to support. They're all very young, 8, 10, 15 years old. He completed up to 11th grade, Your Honor, and at this point, I just want to emphasize how financially it is very difficult for him to pay any kind of cash bond or even good bond will be very hard for him to pay for. We would like to request for signature on bond if Your Honor is not inclined to give him a signature on bond. I do understand that part. So we asked for maximum $2,000 good bond. There's already FTA bond that is $10,000. And I think he was in jail. That's why the FTA happened. We would like to request for no further violent contact. Thank you.
Okay.
Again, Your Honor, the states would just renew its request, given the defendant's history of family violence, given the defendant's history with this particular defendant. The defendant also has 2 battery family violence convictions. One of them was in 2016, and then we have this one, Your Honor, and he FTA'd on the 6/21. And Judge Beckson, which was set for final plea, Your Honor, in which he asked for a jury trial. So again, the state is going to renew its request for a $6,000 cash bond and to stay away from 1096 Fountain Drive and no further contact with Ms. Sierra Ketchum.
Your Honor, his mailing address was changed and the mail was never forwarded to him. 2 times it was returned to the sender, which was the court. And our office, Mr. Murphy actually representing him for the other case. And we thought this was resolved, Your Honor. He thought it was resolved.
As
You
Your
thought
Honor,
it was resolved?
But
No.
I chance to verify every fact yet.
I'm not sure how he could have thought it was resolved. And
Excuse
the
me,
mail
Judge.
being returned twice, it is his duty to keep his address updated with the court so that he will get the proper court notices. So I'm not really hearing that part of it. And I'm not going to belabor the case too much longer. The defendant and the victim both have their hands up, and that's probably because they need to testify about some other things that are outside of my scope that I'm going to listen to today, deciding about bond and whether someone returns to bond. This bond is very recent, and it's recent enough for me to be very concerned about it. I'm concerned about the victim's safety. And the facts as alleged concern me. I'm going to ask for a $4,000 cash bond. I'm going to order that there be no further contact with Sierra, and I'm not sure the last name is Ketchum. And I'm going to order a
Yes,
stay
it's
away.
Ketchup.
Ketchup, okay. I'm going to order stay away from 1096 Fountain Drive. No drugs, alcohol, weapons, or guns while on bond. And I guess that's all I ordered this time. Oh, if there's going to be visitation with the children, that be precipitated by a third party, family, friend, or relative. right.
Excuse me, Judge, could I add
Can you give
on?
me the breakdown of the bond, please?
Yes, with the $4,000 cash, let's say 2,000 on each.
Okay, thank you.
Thank you.
Judge, I would like to add on, me and Mr. Jackson, we are married at the moment.
Okay. All right, that's fine. I believe that this just happened a couple of days ago. Want to make sure there's been the ample cooling down period and that you're going to continue to be safe. Okay. So that's my ruling right now. His attorney, that's fine. His attorney will know how to apply for a bond modification if we feel they feel the circumstances have changed. All right, next case.
Number 12, Mrs. Savoy.
Thank you, Ms. Ketchum. Good luck to you. If you need any more services from the victim witness assistants with the solicitor's office, you can reach out to them, okay? All right, you can mute yourself and sign off if you like.
Yeah, I'm sorry, number 10, Mr. McGoy.
Oh, 10, okay.
All right.
This is 23 CR 0043988F. Stephen McGoy, charged at 1 count of battery family violence. Offense date is March 12, 2023. Pretrial, oh, this is first arrest. Pretrial has told me. Go ahead, state.
Yes, Your Honor. Good afternoon.
Good afternoon.
Good. This incident occurred March 12th of this year at 763 Cascade Avenue. And this is where Miss Carol Walker told officers that she and the defendant, whom she lives with, they were arguing over the payment of a utility bill at the residence. And the defendant went inside her bedroom and he began unplugging electronics in her bedroom. And then when Miss Walker attempted to stop the defendant, he punched her in the face. Officers noted in the warrant that Miss Carol had redness in her face. Your Honor, Miss Carol Walker also told officers that the two of them have had domestic violence quarrels in the past, but none to this extent. Our office did speak with Miss Walker today, and she let us know that they're roommates. And since this incident took place, she's left the residence, but she did confirm the events listed in the warrant. She let us know that she actually sustained a black eye from being punched by the defendant, Your Honor. She let us know that she does not want any contact with the defendant. She hasn't had any contact since the incident, and she doesn't want any contact. So for these reasons, the state's recommendation is a $3,000 surety bond. We're asking for a 1-day anger awareness course, no further contact with Miss Carol Walker no stay away order since since Miss Carol Walker has left the residence, so no stay away. But we're also asking for no alcohol, drugs, or weapons while out on bond. And I believe Miss Walker is on Zoom, so I would like to sound for her.
All right, Miss Carol Walker. Carol Walker.
Well, she was.
Don't know that I see anybody with that name. I see a few Zoom users. But we'll proceed. We'll see what happens. Go ahead, PD Wills.
Thank you. My client is 56 years old. He has resided in the state of Georgia for the past 7 years. He is currently employed by Georgia Works as the Director of Operations, and he's been employed there for the past 5 years. He will not qualify to be represented by the Public Defender's Office. He has some college. He does not have any children under the age of 18. And he states that on this date Miss Walker, he allowed Miss Walker to move into his residence. She had fallen into hard times. They had some disagreements about her not paying her share of the bills or paying for utilities. So he went in her room. She had the light on. It was during the day. He went to shut the light off. An argument ensued. Before the argument could even get off the ground, my client states that Miss Walker called law enforcement. Then Miss Walker also initiated physical contact with my client. My client did hit her back in self-defense. Miss Walker also had a knife in her hand during the time of this incident. My client states that during this time, Miss Walker, while she was living in his home, he almost had her evicted. She was smoking marijuana, which is against the rules of his lease, as well as drinking every day, which may have contributed to her agitated and escalating behavior. My client does not have any criminal history. Again, he is 56 years old. He is a working man. I've reached out to his employer to let them know where he is. Ms. Walker no longer lives in his home. He has blocked her from all from his phone as well as social media. He desires to not have any further contact with her or speak with her ever again. This incident did occur back in March. So for all of those reasons, I would request a signature bond, Your Honor.
All right. I'm going to order the $3,000 signature bond. I'm going to order that through the jail. I'm going to order no further contact with Carol Walker, not to come within 200 yards of her, not to contact her via social media or any means, no other third parties or her jobs. I will order no drugs, alcohol, weapons, or guns while on bond. And I believe that is it for now.
Thank you, Judge.
Mhm.
Your Honor, I sincerely apologize, and yet I have to talk about this. The previous case, Mr. Jackson's case, incident happened on July 2022. I think the calendar has a mistake for having two dates for July 12 and 2023. He was in jail on July 12, 2023 at Monroe, Georgia, Your Honor. He has been in the jail for last 8 days. So it's impossible for him to have second offense on July 12, 2023. So this happened 22, Your Honor. Cash bond is
I
very
do see the yeah, PD Kim, I do see the dates there. What say the state
It's 22, Your Honor.
it is 22. And I was focused, I saw 23, which I was saying this just happened some days ago, but I do see PD Kim's point. What is the state's argument on that?
The state's argument, Your Honor, is that Your Honor has already made a bond ruling. The second argument for the state is going to be given the nature of these charges are extremely similar to the charges as the original family violence case. This defendant does not know how to keep his hands to himself and off of this victim. This defendant has fled, and then by PD's Kim's own assertion, this defendant just got released from another county while being out on a bond, Your Honor. So this defendant clearly has a high risk of reoffending, has a high risk of fleeing, and is completely not warranted for a signature bond or anything below the $4,000 that Your Honor has set. Originally, the state asked for a $6,000 cash bond. So the state understands that Your Honor has made her ruling, and the state will ask that Your Honor sticks to that ruling that was made. Thank you.
Your Honor, I apologize for interrupting again, but he was arrested for this particular charge only in Monroe, Georgia. He was not released from another charge. It was same charge. He was transferred from Monroe, expedited to here, the Fulton County, for this charge. So he's been in the jail for 8 days already for this charge. He lost job. He lives totally separately from her. Your Honor, he's qualified for public defender services. He has no money right now. And how in the world he's going to pay for $4,000 cash bond? We would like to request for $4,000 a surety bond, Your Honor.
The state
On the 21 CR, the 21 CR case.
Yes, Your Honor. On that 21 CR case, just briefly, the bench warrant and failure to appear for those hearings happened in June of this year. He had returned to sender documents, discovery, and his arraignment all in 21 and 22. So the current assault that is in front of the court from July of 2022 had happened contemporaneously around the time this defendant stopped coming to court on the case he was already out on bond for.
Okay, that's what I wanted, that timeline there. Thank you for that, ASG Allen. And it's just too close in time, and I understand your point, PD Kim, but it doesn't move me to change my ruling that we shouldn't keep having incidences. We don't want to, 2 may not sound like a lot to anybody, but 2 could be just enough that we have a different type case on our hands. So I'm going to stand by my ruling for now.
And Judge, who is this?
On the may I say something?
Jackson, number 8.
May I say something, Your Honor?
Oh, that's the case.
Mr. Dennis Murphy told me that this case had been resolved the last time we went to court. He told me there was no more reason for me to come to court. So that's the only reason that I didn't come. I would show up. I don't have a problem with not coming to court. I was already pleaded not guilty. I thought I had, the case was resolved.
How did you think it was resolved? Who told you not to come to court?
Mr. Dennis Murphy told me the last time we went to court that everything was good, that I thought the case was resolved. I didn't think I had to come back to court again. I never talked back to Mr. Dennis Murphy. He was my public defender at the time.
Did you plead guilty and think the case was over?
No, ma'am, I pleaded not guilty.
So when you plead not guilty, you know that means the case is not over. You're waiting for trial.
But that was before, and then we went back to court, and he told me that that everything, when we left the courtroom, he spoke to me and my wife in the hallway. He told me that everything was good. He said, the case has been resolved. You don't have to worry about anything anymore. It's all over with.
Well, I would call Mr. Murphy if I didn't think it was going to take all day, but I don't believe he told you the case was resolved. You'd have to turn to court. You didn't get a document that said that the case was dismissed. You didn't get a document to say the case was no pros, and he would have explained that to you. Now, maybe he said, I don't know what your next date is. Keep your address current and we can contact you to let you know when you need to come back. But I can't imagine he said your case is resolved and you don't have to return to court.
I didn't have to worry about anything else after that day. He said the case is you good. He said, I told him I didn't have a job at that time, and it was something they had wanted me to do. He told me he was gonna pay for it out of his own pockets, man. I swear to God, like you can call him and ask him. This is what he told me.
But that does not, I think that you have enough knowledge to know that you have to get documentation and paperwork to tell you the disposition of your case, especially if it's closed, resolved, or played out. I've not had people that FTA to say my attorney told me not to go to court. That's a new one for me.
I did an FTA on purpose. I just didn't know I had to come to court. I don't mind coming to court. I showed up every other time. Why wouldn't I show up then?
Because you had another case.
I didn't have another case.
I think that ASG Allen read me those dates are very close.
Everything was resolved. We had nothing else, man. I'm like,
isn't that true, ASG Allen? And then I'm going to move on. When you didn't show up, you had the other case. Isn't that correct?
So the multiple dates in the case that has a current failure to appear bench warrant, it was set for a final plea in March of 23, in September of 22, which would have been just a few months after July 22 when this incident occurred. So the gentleman in front of you now failed to appear or appeared for a final plea in September of 2022 after this most recent assault in July of 2022 on a case against the same person, his wife, and it was reset and he pled not guilty and wanted a trial. So ostensibly he was in court in front of Judge Besson on a prior incident against his wife and had already committed the incident he's in front of you now on, and then stopped showing up to court.
Right, because he figured he was getting ready to go back to jail. I'm going to stand by my ruling. your attorney can submit a motion for review or bond modification at the appropriate time. I thought I was pretty clear on the facts. And I think that I'm clear enough to give my ruling. You were out on a $5,000 surety bond. All right, thank you. I'm gonna move on.
Number 12, Mr. Savoy.
This is 23 CR 004399F. It's at Ronnie Savoy, charged with 1 count of criminal trespass and damage to property, 2nd count of battery, pretrial.
This is 10th arrest. Last was 2022 sale of marijuana. That's open, 22 CP 212932. Before that was 2014 possession of marijuana with intent, possession of a firearm during a commission. That was a conviction. He went to felony earlier. I'm not sure what his bond was. I'll have to look and see.
Okay. All right, state.
Yes, Your Honor, this incident occurred June 10th of this year at 1900 Meador Avenue. And this is where, I'm sorry if I mispronounced the victim's name, Ikatar Kishi, that's spelled Iqtadar. Last name Kirshi is Qureshi. The victim showed officers a video of the defendant and himself and Mr. Kirshi arguing. And in the midst of the argument, the defendant punched Mr. Kirshi in the face, causing him to have 2 lacerations. And then the defendant took a brick and smashed Mr. Kirshi's window shield. Officers also looked at surveillance footage of the defendant smashing Mr. Kishi's window. Mr. Kishi is the landlord of the defendant, and he was upset about some landlord-tenant issues they were having. Our office did speak with Mr. Kishi today, and he let us know that he gave us the defendant's residence, and the incident location happened at Mr. Kishi's residence. He also confirmed the events listed in the warrant and the police report, and he stated that after the incident, the defendant threatened to shoot up his house and vandalize his home. Mr. Kishi also let us know that he let the defendant know that if the defendant apologized for hitting him and he paid the $400 worth of damage to his window shield, that he would forgive him. However, Mr. Kishi did let us know that he does not want any contact with the defendant and he wants him to stay away from his residence. So the state's recommendation for bond is a $5,000 surety bond. We're asking for $3,000 for the battery and $2,000 for the criminal trespass to property, a 1-day anger awareness course, no further contact with Mr. Kishi, and to stay away from the incident location 1900 Meador Avenue, as well as no alcohol, drugs, or weapons while out on bond. And Your Honor, for the case that the defendant had earlier, I'm looking up the bond, but the case number in that is 23 PF 005146, and that's for aggravated assault and reckless conduct, which happened just a few days, like around the same time as this incident happened, just a few days later, Your Honor. So this defendant has a propensity for violence.
All right, PD Kim.
Yes, Your Honor, my client, Mr. Savoy, actually turned himself in voluntarily, Your Honor. He's not running away. He's the one who actually came to the court, to the jail, to take care of this matter. He paid $10,000 to Mr. Qureshi to buy the house. I believe that there was a house purchase deal between Mr. Qureshi and my client, Mr. Savoy, and they settled all the issues at the court, Your Honor. I believe my client he's working at AC Battery as a machinist. He completed GED, and he has been here in Georgia for 37 years, Your Honor. He's not going anywhere. Besides the felony charges that he had, he got no bond. So he's definitely not going anywhere, Your Honor. I would like to request for signature on bond for these two charges. And if Your Honor is not inclined to give him a signature on bond, we ask for $1,000 good bond for each charge. So totaling $2,000 good bond. He will still be here, Your Honor. Thank you.
And just quickly, Judge Mincy, I neglected to sound for the victim. If he's on Zoom, which I don't believe he is, I would still like to sound for him right now.
All right, I think it's Mr. Koresha. Anyone involved with the case of Mr. Savoy? All right. And I don't know if I was pronouncing that last name right of the victim, but
Mr. Savoy, please, you have a right to remain silent. I do not want to hurt your case in any way, so please do not say anything about the facts of the case.
all right, I'm going to order the $5,000 surety bond, $3,000 on the battery, $2,000 on the criminal trespass and damage to property. No further contact with the victim. Aquadar, Koresha. And stay away from 1900 Meadower Avenue. No drugs, alcohol, weapons, or guns while on bond. That's all our order for now.
How you doing, Your Honor?
Your lawyer's gonna probably tell you not to talk.
I totally understand. I just wanted to say one thing. I actually went to court. Mr. Koresha took me to court yesterday before I turned myself in, and we had a mediator. That me, Miss April Smith, the one who took the other one out on me, all of us was together yesterday. And we went to Fulton County Courthouse yesterday. We sat with a mediator yesterday at court yesterday before I turned myself in. And actually me and Mr. Koresha, what she said, he told me to apologize. We came to terms. And I apologized to Mr. Koresha. And he told me as long as I pay him, everything was going to be okay. So I don't know, he told her that days before, but if you go look at Fulton County, I just was in court yesterday, ma'am. That's all I wanted to say.
I don't believe you weren't in court on this yesterday.
No,
I'm sorry?
No, ma'am, it wasn't on court. He took me to court because I purchased about a house in the year 2000, which this is the third year of me purchasing, the house, leasing the house to buy.
Well, I'm assuming that's a civil matter that you were in court on yesterday?
Yes, ma'am.
And not the criminal matter that resulted from the same situation.
No, ma'am, but we did discuss, when we went to court, we did discuss about me paying him about his window, and I did apologize. I just wanted, because she said he told her that he didn't want to speak. He didn't speak yesterday.
Does the state have any comment as to the relevancy of that information?
No, Your Honor, it's not relevant in this. That is a civil matter that was handled yesterday. We're in front of here trying to do a bond for the criminal matter where he smashed the window and punched him in the face.
All right. I'm going to stick by my ruling of the $5,000 signature bond for now. Your attorney will know how to apply for a bond modification if that is the case. Okay.
Thank you so much, Your Honor.
You're welcome.
Your Honor, you said $5,000 signature or good bond?
I'm sorry, good bond, good bond, good bond.
I guess we have 13, Mr. Smith.
23 CR 004400J. Donovan Smith, one count of simple battery, family violence, pretrial.
Fifth arrest, last was 2020 shoplifting conviction. 2015 possession of cocaine, PTI. 2020 reckless conduct, NOLO.
All right, state.
Yes, Your Honor. So this incident occurred April 27th of this year. And this is where Miss Courtney Powell told officers that she and the defendant, who is her child's father, they were arguing. And the argument started when she asked the defendant to watch their child for the weekend so she could celebrate her birthday. And the defendant came home and they continued arguing. While she was in the bathroom with their child, the defendant then punched her in the head as she was holding their child. But officers noted in the warrant that she didn't sustain any injuries. We did get the opportunity to speak with Ms. Powell, and she let us know that they are in a relationship and they're actually planning to get married, Your Honor. However, Ms. Powell did confirm the events in the warrant. She let us know since this incident, they have been going to therapy, and that this incident was the first time that the defendant had been violent towards her. She did let us know that she's not in fear of him and she wants to have contact. However, the state's recommendation for bond on this case is a $3,000 surety bond. We're asking for a one-day anger awareness course. We're also asking for no further contact with Ms. Powell, to stay away from the 401 Holderness Street address, as well as no alcohol, drugs, or weapons while out on bond. If Ms. Powell is on Zoom, I would like to sound for her.
Ms. Powell?
Yes, Your Honor.
Yes, do you wish to?
Yes, I do.
Hold on. Raise your right hand for me, so I can swear you in first.
Okay.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, what were you going to say?
So that's not what happened in the statement. Well, that day during the altercation. I also would like to add that since the altercation, me and Donovan attend church every Sunday. He has also been counseling with the pastor for his anger. So we haven't had any other issues. Everybody's fine. The kids are fine. And yes, he also he take care of me and my other kids. That's not his biological children financially.
Okay. Any
And
cross-examination? Huh?
Yes, just briefly. How you doing, Ms. Powell?
Hey.
Hey, how you doing? So on this incident, did you call the police?
I did not.
Okay, well, did he hit you on this incident?
He did, but my baby was not in my hand and the altercation did not start in the bathroom.
Okay, but who called the police, Ms. Powell?
I'm not sure.
Okay, all right, that's all, Your Honor. I'd just like to add the police came out there. There was a statement made in the warrant that Ms. Powell was hit, a child was involved or around the incident, but no injuries were alleged. But the state's recommendation is the $3,000 surety bond, along with the previous mentioned conditions, Your Honor.
All right. PD Kim?
Yes, Your Honor, my client is 34 years old. He was born and raised here in Georgia. Musician, that's his full-time job, and yet he also works at Gen Pro as a cleaner for the commercial buildings. Your Honor, he has never missed his church for the last 5 years. He's very serious about his commitment, and they are trying to get married. This happened 3 months ago, Your Honor. My client and complaining witness, Ms. Powell, they all want no further violent contact. So we would like to request for that. My client has 3 years of college education, and they are trying to get their house together. We would like to request for a signature on bond and no further violent contact. Thanks.
Ms. Powell, are you in fear of Mr. Donovan Smith?
No, Your Honor.
Okay. Do you want to have any contact with him?
Yes, I do want contact with him.
And you all do or don't have children together?
I'm sorry, what you say?
Do you all have children together?
We have children together, but he helped me raise my other 4 kids.
Okay. How old are the children you have together?
She'll be 1 next month. Get it out of her mouth.
You just have the 1-year-old together?
Yes, ma'am. Well, she's not 1 yet, but yes.
What's she putting in her mouth?
All right, I'm gonna order the $3,000 surety bond, $3,000 surety bond. I'm going to order, no further violent contact with Ms. Powell. And, no drugs, alcohol, or weapons and guns while on bond.
Your Honor, can I say something?
Who resides at the Holderness Street? Both of you?
Yes.
Okay. Well, I haven't ordered to stay away, and I said no further violent contact, so we can come back to be there, but as long as you don't have any violent contact.
Your Honor, can I say something?
Quickly.
He don't have any prior to where he missed court. He attends all his court dates. Is there
That's
any
just
way?
one of the factors. That's one of the factors. The other is his criminal history.
Yes, ma'am, but it's just us. I don't have any money. Donovan is the financial support here.
Right. Well, 10% bond, give or take. So I am going to stick by the ruling of the $3,000 surety bond.
Okay.
All right. All right. Thank you. Next.
Got number 14, Mrs. Smolinski.
Theodore Smolinski, 23 CR 004401E, charged at 1 count of battery. Pre-trial.
This is fourth arrest. Last was on the 3rd of this month out of Gwinnett. Criminal damage to property. Hold on. Okay, that's what the bond assessment stated. He's on probation for criminal damage to property. Disposition date was 2020. They gave him 2 years to serve, 10 years probation for that. And the previous arrest was 1998. Go back. That's it.
Okay. State.
Yes, Your Honor. So this incident occurred yesterday at 1717 Central Villa Drive. And this is where officers arrived and they saw Mr. Billy Bromell sitting on the kitchen floor with blood on his shirt and blood on his face. And officers spoke with Mr. Bromell, who stated that the defendant gave him a key to the defendant's apartment, so that he could look over it as the defendant would be away for some time. And Mr. Bromell told officers that the defendant told him he could stay. And then on yesterday, the defendant came home and he saw Mr. Bromell sitting in his residence. And so the defendant asked him, "What are you doing here? You have to get the F on." And then Mr. Bromell, he stood up, and as he got up, the defendant pepper sprayed him, and then he punched him several times. Mr. Bromell said that after being pepper sprayed, he couldn't see for about 4 or 5 minutes. And so then he walked to the kitchen, and that's where the defendant told him he needed to sit down. And so that's Mr. Bromell's account of the incident. And so we were able to speak to him today, and he let us know that they've been friends for about a year and that he's been staying at the residence for about 3 or 4 months. Mr. Bromell confirmed the events that were listed in the warrant, and he stated that he had to go to the hospital after being pepper sprayed. He let us know that his eyes are still burning and they're still red and he was having difficulty sleeping last night from being pepper sprayed and attacked by the defendant, Your Honor. So for all of these reasons, the state's recommendation is a $3,000 surety bond. We're asking for a 1-day anger awareness course, no further contact with Mr. Bromell. And if Mr. Bromell is going to still be at that residence, we'll be asking for a stay away at 1717 Central Villa Drive. And I believe Mr. Bromell's on Zoom, so I would like to sound for him.
All right, Mr. Bromell. Mr. Bromell.
Mr. Bromell, you have to unmute yourself.
Can you hear me?
Now we can. Do you
Thank
wish
you
to
for having
address,
me.
right, do you wish to address the court today?
Yes, ma'am.
All right, raise your right hand so I can swear you in first.
Okay.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes, Your
All
Honor.
right. Are you in fear of Mr. Smolinski?
And fear, no, I'm not. I'm not. And, I think he's, and I asked him once before about being angry at every little small thing that goes on. I mean, putting the wash and dryer and stuff like that together, which I purchased. I made the purchase on it, and it's sent resident. And it just kept going on because I told him, I said, man, I don't mind you getting on me, but I said I don't mind you getting on me, but I'm just like a brother to you. And I just don't want you to think because I give you permission, you can talk to me like an animal. And that was what started taking place. And then, everything started escalating. So, but I spoke with Miss Tanya at the office. And I'm waiting on my birth certificate and all so I can be on the lease. I asked to be on the lease, and that's been prolonged because I want my birth certificate so I can get on it. But he told me when I got there that was okay, that you can stay and look over the residence while I'm gone. And as soon as they started seeing what was going on, they was like, well, you have a tenant in your place. And I went there kindly and told them, I said, yes. I said, well, I'm waiting on my birth certificate and all, so I will be able to stay there and, and watch over his place. And I don't mind giving him extra money for staying because he don't stay there, but he's not even there 90, 98, 99 percent there. He comes home every 2 or 3 weeks.
Okay,
So,
1 second. I'm sorry, Your Honor, Mr. Bromell. Just 1 second. Just quickly, Mr. Bromell, are you staying at that residence currently?
yes, I am.
And let me ask, do you want contact with Mr. Bromell? I mean, not Mr. Bromell, but the defendant in this case?
Sure.
You wouldn't mind contact?
I don't have no problem with that. I mean, as long as he be able to, deal with me as a man and talk to me as a man so I can talk to him, because, that's the way I want life is to be.
Okay. All right. And I just would like to confirm on yesterday, the defendant did pepper spray you and punch you.
That is correct.
Okay. Thank you, Mr. Bromell. Judge Missy.
Yes, ma'am.
All right. PD Kim?
Yes, Your Honor. Your Honor, the story is not like that. House is actually the place belongs to my client, Your Honor, and he has every right to protect his place. He asked Mr. Bromwell to leave the premises, and there was no requirement for eviction to be filed because it was not more than 30 days. He was there for a few days and he politely asked him to leave. Mr. Bromell would not leave. And my client changed the lock for the apartment to make sure he doesn't come back. And however, Mr. Billy was still in the premises. That was really shocking to my client, and he was scared. He was defending himself. Your Honor, it is his right, my client's right, to protect himself and his place at his place. But for any kind of invasion, Your Honor, he was doing self-defense. My client is 52 years old, and he has children are all older. He's working as a truck driver for Western Express. He graduated from high school in Roswell. Your Honor, he also served in the military as a veteran from 1992 to 1996, Marine Corps. He's 40% disabled, and yet he's still working. He's been here in Georgia for 39 years. He deserves to be at his home with peace. We would like to request for signature on bond, and we are just kind of shocked why Billy Bromell was not arrested for invading into somebody else's house. without permission. Thank you, Your Honor.
Okay. And so, Mr. Brumell, you do not want contact, correct?
I said, yes, he can have contact with me.
Okay.
Certainly. I mean, I'm not going to turn my back, but everything was, was said what I said, that I was there for the amount of time that I was there, and there wasn't nothing going on until up to the last, week or two, and then things started to fall apart.
Mm-hmm.
And he helped me out. He actually helped me out to do my to get my birth certificate online.
Mm-hmm. So
probably have my information, all my information in his phone on that terms, but I'm just telling you just how it is.
Right.
I don't
I
have a reason to
appreciate
lie
that.
about it.
I
Yes,
appreciate
ma'am.
that. Who lives at
And,
the 1717 Central Villa?
Ma'am?
Whose address is the 1717 Central Villa?
It's Ted's. It's Theodore. That's his name. And and I was looking forward to getting my birth certificate because I already filled out the information to give to the Atlanta Housing to be there. And I spoke to the Atlanta Housing, and they told me it was it's not up to the where the Atlanta Housing said, hey, we don't have anything to do with the lease. We don't have anything to do with the lease. Okay. And he said it's up to the managers at the apartment complex to, and it's up to Ted, whatever he wants to do. But he wants me to get the lease. I mean, he wants me to get the lease signed so somebody can look after his place. And now he's just changed his mind. He's changed his mind on it. And I don't understand that. I don't understand it.
Your Honor, may I add, this is the defendant's residence. And however, Mr. Brahman has been staying here, and it's, I guess, how do I say, not in great taste to put the victim out of somewhere that he's been victimized at. So I guess if an escort, the defendant could go back to his home if a police could determine that Mr. Bromell is no longer in that residence for however long as it takes, or as the proceedings go on in this case, Your Honor.
All right. Well, I have two concerns. If I don't do a stay away and Mr. Bromell goes back, then we don't want the police to be called again.
Right.
We have to make sure the victim is going to be safe, which is Mr. Bromell, wherever he resides, and just trying to sort that out and do what will hopefully be best for both of these roommates, I guess, for lack of a better word.
Yes, Your Honor, it's such a short notice for this to take place, and right now I don't have a place until I get my birth certificate, and then I can go out on my own. I'd be more than welcome to do that.
Mm-hmm.
Yeah.
And I know that PD Kim, you may not want Mr. Smolinski to say anything, but
if you're a man about it, if he's going to be a man about it, I can be a man about it, and we can talk it over and work things out. I don't have no problem.
That's kind of not how it goes at this point, right?
Right, because I'm at age right now. I'm 65 years old, and so I'm trying to, do all I can. But I just started the service that I have, and I just got a new client, which calls Touche's over, and I got it. I can do that, and plus I got a contract with the Malones, so that's going to start next week. So I'll be in good shape. I can be in good shape and do whatever I want to do.
So are you planning then to move out in a couple of weeks?
Yes, ma'am. Try to get that. Yeah. At least a
Okay.
month. Give me a month and I can operate, but I'm not gonna say nothing. I'm not gonna argue with him. And certainly he shouldn't argue with me about, because this takes away from me. And surely it took away from him. Because we could be a man about it. Just say, hey, all right, let's go to the office. Let's talk to him and see what could take place or what can transpire with this. So we both won't be in the middle of it. They can say, hey, Mr. Bromell, we understand that you're waiting on your lease. I mean, not the lease, well, wait to get your lease and waiting on your birth certificate to come from North Carolina, and we're gonna work with you. And that would have summed everything up instead of, trying to take matters in your own hands. Sometimes you can't do that. You can't take matters in your own hand. There's laws be made. There's laws that's impact stuff like this.
Right.
Honor, this situation is really weird because my client has to be kicked out from his own place. They were not roommates. And I mean, my client is the leaseholder, Your Honor. This is his place. He's the one who has to be protected.
Well, I wouldn't say the leaseholder in a situation of battery or some type of violence needs to be protected. Our first concern is to the victim to be protected. As ASG Bickerstaff has stated, and I was going to put a date on there as far as the time frame that Mr. Bramelli could be there. Bramell, I'm sorry, I keep putting an I on the end. Pardon me.
That's
Mr.
okay, Young.
Bramell-
That's okay.
Mr.
That's
Bramell
okay.
could be there. I don't normally get that involved in intrinsic in it, so that again, we don't put people in situations that are not going to be positive for them going forward. But I understand Mr. Bramell may need somewhere to live because he's been there. And I definitely
Senora, could you speak up a little bit, please?
Okay, I am trying to think it through. Don't have a lot of time. I'm going to do a $3,000 signature bond.
Gonna do what now?
I'm going to order a $3,000 signature bond. Gonna order that signature bond through the jail for Mr. Smolinski. As far as the contact between the two of you, I'm going to order no further violent contact. But this has not been 24 hours. There needs to be a cooling down period. Need to make sure that this incident is finished and over. And usually it's not so fast within less than 24 hours. We don't want the police coming back. We don't want any more incidents or violence. And we don't want you, Mr. Bramell, as the victim to undergo any more incidents. So what I'm going to do is you asked for some time so that you could do this. And I know, again, Mr. Smolinski is not going to be happy with it. But I'm going to say that you would be there a couple of weeks. Today is the 14th.
I think he left, didn't he?
No, no.
He's still there?
Yes.
Where'd he go?
Just briefly.
Are his cameras off?
I don't see him on the Zoom no more.
Oh, he might
No, I don't either.
So, okay.
It dropped. I was going to give a date.
Well, he gone.
Yeah, his phone might have died.
I would just like to object, Your Honor, to the $3,000 signature bond through the jail and the no further violent contact, specifically because this incident just happened yesterday. And Mr. Bromell complained of not being able to sleep. And his eyes were still burning. He had to go to he was hospitalized from being pepper sprayed yesterday. Although Mr. Bromell saying that he doesn't mind having contact with him, but obviously tempers are flared where the defendant felt the need to punch him and pepper spray him opposed to putting in an eviction notice to get Mr. Bromell out of his house. Instead, he decided to assault him. So the state would stand firm on the $3,000 surety bond, along with the no further contact with Mr. Bromell right now. I know it's not ideal to kick the defendant out of his residence, but it is unfair to kick the victim out of somewhere he has been assaulted.
He was not assaulted. My client was defending himself from invasion to his own private place. Somebody came, unlocked the door, and yeah, he was the one who attacked my client first. My client wanted to defend himself.
Well,
we have no objection to no further contact.
Right. Let's do that. No further contact with the victim.
And I would like to request for a one-time law enforcement officer to verify that Mr. Bromell is not there. Then my client should be able to go back to his own place, Your Honor.
Right. And that may be in a couple of weeks. It doesn't sound like Mr. Bromell is able to leave tomorrow. So, Mr. Smolinski, I'm going to order a stay away from the residence until you return with law enforcement to ensure that Mr. Bromell has moved out of the residence before you're able to stay there. Okay? That's the only way I can kind of go through the middle of this. And it may be 2 weeks, it may be 3 weeks. So hopefully when law enforcement go, and I would say give it at least a week or so, they will be able to speak to Mr. Bromell and determine what date he will be moving out so that you will know what date you need to return with law enforcement to do that investigation or to do the sweep of the home to determine whether Mr. Bromell lives there. So when you make bond, I'm going to ask you to at least give it a week before you go there first and let the officers know you may have to go back a second time. And if you wait a week, that would be the 21st, 22nd, give or take. But you've got to go back with law enforcement to begin with and not take matters into your own hands. And again, that's no further contact and no drugs, alcohol, weapons, or guns while on bond. Is my ruling clear?
So I'm in town every 2 to 3 weeks. I will drive over the road with semi trucks. I just came in town yesterday, noticed his stuff is still in my place, which I told him 2 weeks ago. He had some things in my spare bedroom. He said he was just doing some laundry. I said, this stuff needs to go. I had a notification on my door because he keeps going in and out of my apartment more than I expected him to. They're supposed to just be doing maintenance issues and making sure they were fixed by the maintenance people of the complex. So he decided, when I got back yesterday, my spare bedroom is full of clothes in garbage bags and everything else all spread out through this bedroom. And I'm like, why is your stuff in my apartment? I never gave you permission to be in here. This whole thing of him doing this for months in my place is a misnomer. He is misspoken and is not correct. I am in town till Monday afternoon. I need to get clothes to get packed to go back on the road for 2 to 3 weeks. And if I need to go, I'll go back on the road tonight or tomorrow, whenever I bail out. But I need to get my clothes.
Okay.
And my hygiene and everything else that I need for my trip.
Okay. So what we'll do is we'll allow that one-time law enforcement escort for you to go back to the property to retrieve your ID, your personal belongings. That's the one-time escort. And then in a couple of weeks, you can arrange for a second law enforcement escort to determine if Mr. Bromell has moved out, and then you can occupy the residence. But they have to be able to.
That's what I waited on this last time I was out of town to see if he got his stuff out, but no, he put more stuff in.
Right. Well,
so I need to know when he can leave.
Yeah.
I mean, I guess I have a question just briefly. This sounds a little complicated and it sounds like a mixture of some civil and criminal situations, but it sounds like at this point, there's a dispute between whether or not the victim was allowed to stay and remain in the location.
Mm-hmm. Sounds
Um,
like it.
And then assault occurred. Or an altercation occurred, since Ms. Kim doesn't like that word in this situation. I believe it would be appropriate to explain to the defendant that he needs to maybe go through the eviction process. It doesn't
Certainly.
appear that the dispute about the right to be in the location is going to be resolved at this point. And so the state is concerned that should the defendant receive and make a bond, the continued issue about our victim remaining on the property is going to continue to escalate.
Right. I am too.
On the lease,
Yeah.
not receiving any mail at my location.
Sir,
I
hold
just-
on a moment, please. You're represented.
Yes.
Strongly recommend you to stay silent.
Yeah, that doesn't impress me. I'm not concerned about that. It's just the physical presence. Since I know that Mr. Smolinski, as he stated, can get on the road and can be gone, I think that's going to be the best thing, is to stay away for the defendant, to allow the victim time to move and get his things away from that property. I don't know how long that's going to take. I am interested, in making sure that the victim is safe and can live there peacefully while he is, as he says, working to get money to move. So I'm going to still order the $3,000 signature bond through the jail, stay away from 1717 Central Villa Drive until the victim, with your police escort, has determined that he's moved. You will get that one-time initial escort to go back and get all your personal belongings. And then in a couple of weeks, you can go back with the officer again to determine if he's moved before you can stay there.
So how do I determine that before I have to show up with an officer to determine if he's moved or not?
Right.
So how does he have all these rights to my place? I don't get it. It doesn't make sense to me. One bit. If I give a key to someone, if I had a fish and I give a key to someone to feed my fish every 2 days, they have the right to move in all their junk to my bedroom, and all of a sudden they're a squatter in my place and they're able to live there?
That happens a lot these days.
I
And
bet it
there's
does.
a civil process.
Going on right now.
There's a civil process to go through for that, but it does happen quite often. So you have to be careful of that. Unfortunately, that's all I can say to that, because I'm not giving you advice and I don't represent you. But as a judge, we hear a lot, and we hear a lot of things that happen. So you have to be careful. That's all I can say to you. But it is not unusual at all, and it's not unique to you. So that is what the ruling of the court is to stay away, one-time escort to go back, and no further, and I don't remember, did we say no further contact or no further violent contact? I think PD Kim agreed to no further contact. Okay, no further contact. And no drugs, alcohol, weapons, or guns while on bond. You'll probably have to look at some civil avenues once you're out, as the ASG has stated. All right. Next case.
Number 15, Mr. Vaughn.
23 CR 000, I'm sorry, 004402E. Vaughn, one count of criminal trespass. This is his first arrest per pretrial. Go forward, state.
Yes, Your Honor, this incident occurred yesterday, and this is where Miss Tashana Austin told officers that her child's father, the defendant, came to her residence, and she told him that she had a TPO against him and that he needed to leave immediately. She told officers that they began to argue over the validity of that TPO, and emotions grew. And at that point, Miss Austin and her sister had to physically remove the defendant defendant from the apartment. And then after leaving the apartment, the defendant admitted to officers that he threw a large rock at the passenger, at Miss Austin's car, causing a football-sized dent and a scratch to her car. The defendant told officers that this was the first time that he was put on notice about that TPO. And so our office was able to speak to Miss Austin. She let us know that they have a child together, and that she called the police because the defendant and her sister had got into an argument on this day. She did confirm that she had a TPO, and that TPO was granted. The case number for that is 2023 CV 382501, but it has yet to be served to the defendant, Your Honor. She did let us know that she confirmed that the defendant did damage her vehicle, that there was damage to her vehicle, but she said that she didn't see that the defendant caused that damage, Your Honor. So for all of these reasons, the state's recommendation is a $2,000 signature bond through pretrial services. We're asking for no further contact with Miss Austin. We're asking for a one-day anger awareness course, to comply with all TPO orders, and to stay away from 419 Chamberlain Street, as well as no alcohol, drugs, or weapons while out on bond. And if Miss Austin is on Zoom, I'd like to sound for her.
Yes, I think I see her. Is it Naisha Austin?
No, ma'am. It should be Tashana Austin. I'm the sister.
Oh, you're the sister to the victim.
Yes, ma'am.
Oh, okay. Were you there at this incident?
Yes, ma'am.
Okay. Do you wish to address the court?
I do.
Okay, let me hear from the victim first, though. Tashana Austin, I see you next to your sister.
And Your Honor, I represent Mr. Vaughn, and I would object to any testimony from Naisha Austin. She's not alleged to be a victim here.
Okay. She's just a witness, I understand. Tashana Austin, do you wish to address the court?
Yes, I do. Good afternoon, Your Honor.
Good afternoon. Hold on a second. Need to swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Briefly, what would you like to say?
Yes, briefly. I do not fear my life of Dylan Vaughn. We do currently have a 4-year-old child that he do provide for very well. He is an outstanding father, right along a stellar individual of community. He do not have any prior offense. And as far as the no further contact, I would like to advise and put in a request that it be no further violent contact. So he would be able to still actively and proactively be a part of his 4-year-old son. And just pretty much just have mercy. And he doesn't have much money. He is a working citizen. And just pretty much just have leniency with him and allow the lowest amount.
All right. Thank you.
Thank you.
Your Honor, my client is 28 years old. As pretrial has said, he's never been arrested. He is gainfully employed. He works. He tells me he does have some college education as well. And he tells me that his 4-year-old son is his life. That is how he described it. We are okay with the signature bond, Your Honor. And no further violent contact. We're also okay with that provision.
And then who resides at the 419 Chamberlain Street?
They both live there together, Your Honor. But if the court had ordered a stay away, then my client said he would be able to find somewhere else to go.
Okay, we just want to make sure there's been the ample cooling down period.
Yes.
And I understand, is there a TPO that's going to prevent him from living there anyway?
Yes, I believe so, Your Honor. He did say that he was not served with the TPO at the time, so he did not know that he was not supposed to go there. So since there's a TPO, I guess he can go there.
Right. So that's what I'll do. I'll enter the $2,000 signature bond through the jail, and I will order the stay away from the 419 Chamberlain Street, but I will order no further violent contact between the parties and to comply with all provisions of the active TPO. No drugs, alcohol, weapons, or guns while on bond. And I believe that's it. Anything else, counsel?
Nothing further, Your Honor.
Thank you.
I have
Yes.
a quick question. Is this, so I'm assuming this is an ex parte order that was just recently issued?
That is correct. Yes.
And it would say no contact, not no violent contact, no contact, period.
Until they have that hearing, yeah. Well, and then, you know, my contradictory language, pardon me, ASG Allen, was to comply with the TPO. So, I know that you're right.
He be served while he's in custody, I guess. I
Right.
can ask a victim advocate to look into that.
Right, because he was not served at the time of his arrest.
Right. So unfortunately, because I know it's going to be conflicting and I don't, you know, obviously want to put him in a situation of being arrested very quickly.
May I say something, Your Honor?
No, hold on a second. So the ex parte TPO that has been issued, unless you're going to tell me that's not, Ms. Austin, that's the only question I would ask you. Is the ex parte TPO been issued?
No, it has not been issued, and I am withdrawing the TPO.
You made an application?
It has
Yes,
been,
ma'am.
Your Honor. We have a case number
Hold on
4.
a second. Hold on a second, Ms.
Thank you.
Austin. Go ahead, Ms. Bickerstaff. So it has, the ex parte has been issued.
Yes.
All right, so the ex parte
I
order,
have,
Ms.
Your Honor, I have confirmed that the actual TPO has not been served. It has
It's not been served. That's
So
not what I asked you.
has-
I asked you had it been issued. If it's been issued, it will be served. So that
why
was not my question. I know he's not been served because now we know where to find him. And so you have gone through with that application process, and a judge heard it and issued that ex parte order.
We have not had no hearing about no court hearing as of yet.
I know that
No.
ex parte means without a hearing. It went before the judge.
Why
though.
would they give you a date for a hearing?
Who is that talking in the background?
Yes, ma'am, that was
I-
me, Asha.
Okay, I tell you what, I'm going to give my ruling, and my ruling is going to be, he's getting a $2,000 signature bond through the jail. It's going to be about 24 hours before he gets out. I'm asking the state to do all that they can do to get him served with this ex parte TPO while he's in the Fulton County Jail before he is released. Usually that just takes a phone call to the sheriff's department to let them know that where he can be found and served. I've had that happen many times. So he will be served with it. And I am going to order that he stay away from the 419 Chamberlain Street, that he comply with all the TPO instructions, and that there be no further contact with you, because I cannot issue this order that he have contact if the TPO says he doesn't. The TPO has been issued. There is a case number, and and obviously you made your application. So if those provisions are removed, then your attorney will have to apply for modification of this bond so that he will not be in conflict with the two orders. That is what I'm trying to avoid, okay? Because right now there's conflict with two different orders. And all that's going to do is get him put in jail.
Your Honor, may my client have a one-time police escort back to the location to retrieve his belongings?
Yes.
Thank you, Your Honor.
All right, thank you. All right, I think that is it. Anything else, counsel?
Nothing further, Your Honor.
All right, thank you.
All right, then number 16, Mr. White.
What was that bond?
It was a $2,000 signature bond through the jail. Calvin White, 23 CR 004403F. Charged with 1 count of battery family violence. Pretrial.
Second arrest. Last arrest was 2022, simple assault, public school employee.
All right, state.
He got an open felony too.
Oh,
23 CP 220156, criminal damage to property. And that open case in state court, it says simple battery family violence, 22 CR 002 791F.
okay. All right, state.
Yes, Your Honor. So this incident occurred March 4th of this year at 2510 Lake Royale Drive. And this is where Miss Destiny Goodman told officers that her and her boyfriend, the defendant, were arguing. And then that argument became physical, where the defendant threw a filled hard Gatorade bottle at her arm, leaving a bruise on her. We were able to speak with Miss Goodman, and she let us know that they're no longer in a relationship, but they do share a child together. Miss Goodman confirmed the events listed in the warrant, and she said, and she let us know at the time she was pregnant when he threw this Gatorade bottle at her. She did let us know that just a few days following the incident, the defendant was arrested in DeKalb County for being violent against her. She let us know that a part of that condition was, a part of the bond condition was to have no contact with her. Miss Goodman told us that she does not want any contact with the defendant, and she wants him to stay away from her residence. And I'll put that in the chat for the litigation manager. So for all of these reasons, the state's recommendation is a $3,000 surety bond. We're asking for a one-day anger awareness course, no further contact with Ms. Goodman, as well as to stay away. Well, I'm not sure if we should stay away from the incident location because Ms. Goodman has a different address, but to stay away from her address that I'll put in the chat, as well as no alcohol, drugs, or weapons while out on bond. If Ms. Goodman is on Zoom, I'd like to sound for her. And just for your knowledge, Your Honor, the open simple battery case, it looks like the defendant got a $1,000 SOB bond through pretrial services, but he has a bench warrant out on that case currently.
Okay.
Yeah, but it was a different victim. Yeah, it's a different victim in that case. It's not Ms. Goodman, but there was just a few days after this incident happened, a violent case involving Ms. Goodman in DeKalb County.
Okay. All right. Go ahead, PD Kim. Oh, I'm sorry. Let me sound for the victim. Miss Goodman, is there a Mr. Goodman on? I think it's just us.
I'm here.
Oh. All right, Miss Goodman, do you wish to address the court?
I would like no further violent content.
That's not my question.
So
My
what's the
question
question?
was, do you wish to address the court? Yes or no?
No.
Okay. And if you don't, and can't say anything, and if you do, I'll swear you in, and then you can talk.
Okay, well, yes, I'll address the court on.
You what now?
I'll address it.
Okay. Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay, I have two questions for you. First one being, are you in fear of Mr. White?
No, ma'am.
Do you want to have contact with him?
Well, we do have a 3-month-old, so I would be more comfortable if he was around. Like, I want to be around while he sees my child or whatever. So I would like no further violent contact because I would be more comfortable being around while he's with my child.
Okay. All right. Any cross-examination by the state?
Yes, just briefly. Ms. Goodman, how you doing today?
I'm doing good.
Good. You spoke with our victim advocate today, correct?
Yes, I did.
And you let us know that the things listed in the warrant were true, correct?
Yes.
And you also let us know that a few days after this incident, you had another violent incident with the defendant, correct?
Which incident are we talking about?
In DeKalb County, where he was arrested?
Yes.
Yes, okay.
Wait,
That's
we
all.
had it. Thank you. No, we haven't. So this incident right here is the first incident that we've had recently in a long time. Mm-hmm.
Okay,
But the other incidents that we had, was like last year in November.
We can't hear you. There's a bad connection.
And we've been around each other since then, like with the bad stuff. So this incident right here from the cab, that was.
Yeah, we have a bad connection. Could not hear what you were saying.
Y'all can hear me now?
Yes,
Yeah.
we can hear you now. When was the second incident in DeKalb County, Ms. Goodman?
It's only been one incident in DeKalb County.
And when did that one occur?
A few days ago, last week.
A few days ago, last week.
Last Friday, the Friday that just passed.
Okay, that's all. Thank you, Ms. Goodman, for your statement. And that just goes to my point, Judge Mincy. We've had this incident in March. We just had an incident last week in DeKalb County for violence. That's why the state's position is the $3,000 surety bond.
All right, thank you. PD Kim.
Yes, Your Honor. My client is only 22 years old, and this incident happened on March 4 this year, and they do have a 3-month-old baby. They have been, I believe my client wants to have a no for the violent contact with her because of the child. And Your Honor, their relationship is still going on, I believe. That's what my client is believing, Your Honor. My client has no job right now. He graduated from high school, and yet he does not have enough financial assets, so he will be qualified for public defender services, Your Honor. He has been here in Georgia for almost all his life, even though he was born in Mississippi. He came to Georgia, and he's been here. He has a strong ties to the community. He's not going to run away from anywhere. We would like to request for signature on bond. This happened a while ago. I think there has been enough ample time of cooling period. We request for no for the violent contact as Ms. Goodman wishes. Thank you.
All right. I'm going to order the $3,000 surety bond. I'm going to order a stay away from Ms. Goodman's home address. I'm going to order no further contact with Ms. Goodman. I am concerned about the other cases as well as the history. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And if there's visitation with the baby, that be facilitated by a third party, family, friend, or relative, so that the parties will not violate the bond with having any contact. All right, anything else?
Can my client have a one-time law enforcement officer visit, escorted visit to retrieve his personal belongings?
Yes. And a
Thank
one-time
you.
law enforcement escort. Excuse me.
Yeah, how much was bond once again? I'm sorry.
That was a $3,000 surety bond. All right, if that's it, that will conclude this case.
Thank you, Your Honor.
I'm going back to number 4, Mr. Gray.
Okay.
Good afternoon, Your Honor. Tyrone Smith, convict attorney representing Mr. Green at this point.
Okay.
And
Your Honor, it turned out that there was a conflict and I represented Mr. Tyrick Plummer yesterday and I didn't realize it until we started.
Oh, okay. Okay. So that was why we were asked to circle back. I get it. I'm
That's
sure.
what happened, Judge Mincy. I was called in at the last minute. She gave me 30 minutes notice.
Well, I'm glad you could put that tie on in 30 minutes. You did
Yes,
good.
ma'am.
Okay. All right, I've written down some notes with the facts, with Mr. Robert Green.
Let me get the history. So you got 12 total, because I don't think council was on here. 2021
Okay.
failure to appear, 2016 probation, 2014 battery DV, it was NOD, 2019 ag assault, robbery, obstruction, theft by taking, first offender. That's it.
Okay.
And Your Honor, just to wrap our arms around the matter, it appears that there are 3 people who were arrested during the same incident. 2 of them have already gone through first appearance and their cases have been accused. Mr. Green is the 3rd. At this point, our office has warrants and we've got a portion of a police report with no narrative. So very little information, but some of what Ms. McLeod conveyed previously is corroborated, although there are lots of facts because the defense gets to talk to their clients, and often that includes information that is not reflected in a police report or warrant. So there's clearly a big story here. But what we have for the court is that Mr. Green and Mr. Lane reside at the same location. Mr. Green and his wife lived there. Mr. Lane was a roommate for a period of time. They engaged in a physical altercation and each were arrested on a single charge of simple assault for punching or striking with a hand the other one who is a roommate. So Mr. Lane has a $3,000 bond, SOB, I believe. And maybe pretrial can help with this, but he's been ordered to not go back to the location. What we were talking about previously is that Mr. Green should be allowed to go home. It is his residence. That's where he lives with his family. Is that correct, Mr. Smith?
Yes, that is my understanding, Mrs. Allen.
And then there's Mr. Plummer, who was also arrested. The facts in his warrant seem to show that he and his wife were present. There was a get together after his friend, Mr. Lane and Mr. Green had this altercation. He responded by taking a gun out of his waistband and walking around with it, basically trying to intervene in a threatening way. And so he's got an additional charge and has already had a first appearance. So Mr. Green, unfortunately, is the last one of the story. He does live at the location. You just heard his criminal history. It looks like he got first offender on a pretty violent case through the DA's office and maybe is on probation still. We'll have to confirm with Mr. Howard. But we don't oppose him being able to go home. He just needs to have no further contact with Mr. Lane, his co-defendant. And maybe Mr. Plummer. Is Mr. Plummer, I believe, friends with Mr. Lane? So
That
that's
is correct.
Yes, Alan, that is my understanding. Mr. Plummer is a friend of Mr. Lane, that Mr. Green resides at the residence with his wife. Apparently, Mr. Lane was talking disrespectfully to Mr. Green's wife and swung at her. Mr. Green interceded, just defending his wife, and swung back. I don't even believe he said he doesn't even believe a punch landed.
Okay. Were you going to say something to Ms. McLeod or the same thing?
No, essentially the same thing, Your Honor. I represented Mr. Plum, of course. He's the one who allegedly had a gun. So when we found that out, of course, I realized there was a big conflict right there.
Right.
And I think I hadn't been able to pull up the bond amounts for the 2 other gentlemen, Mr. Lane and Mr. Plummer, but I'm sure Mr. Howard at pretrial can assist with that.
I thought I was
I
told
wasn't at
about
work when they did this case.
Okay,
so
sorry.
who was the judge law 1500 good bond? Who was that? Was that Mr. Lane, I thought?
That was
No?
Mr. Lane. It was
Yeah,
a
I think Ms. Champion
$1,500
told
good
us.
bond for Mr. Lane on yesterday, and it was a $3,000 split bond for Mr. Plummer, 1,000 sign-on bond through the jail for the first charge and 2,000 good bond for the second charge.
Right. I thought somebody told us. Thank you, Ms. Champion.
And Your Honor, we're asking that Mr. Green be allowed to have a signature bond.
Okay. I think I'm pretty clear. I'm going to grant a $3,000 signature bond through the jail.
Through the jail. Thank you, Your Honor.
And that he will just have no further contact with Mr. Lane and Mr. Plummer. No drugs, alcohol, weapons, or guns while on bond. Okay.
3,000 SOB jail?
Yes.
All right, thank you.
All right, you're welcome. All right, that concludes this case.
Your Honor, you did say a $3,000 signature bond through the jail, correct?
Yes.
Okay. thank
Someone
you.
knows the acronym of SOB jail, it sounds. I won't ask how. But we'll go with that. Yes.
Thank you, Your Honor.
All right, you're welcome.
And Your Honor, that concludes my business before the court today. May I be excused?
Yes, I think we've been traveling in the same circles all day.
All day.
Your Honor, I
Long
believe
day.
my business is concluded as well. May I be dismissed?
Yes, have a good weekend and you can take off your tie now.
All right. Thank you. You take care.
All right, you too.
All right, Your Honor, we cleared here in courtroom 2. May we be excused?
What happened with
Yes, you
Parker?
may. Have a good weekend.
Have a good weekend.
What's
Did we
going
do
on with position 11?
Oh, hold on.
11.
Parker, Elijah Parker.
Oh, he's in Alpharetta. They should have logged on.
Oh, they didn't get on?
Oh, they never got on.
Well, we'll reset them for in the morning. I mean, tomorrow rather.
All right, Your Honor.
All right, we'll reset to Saturday. Maybe they couldn't get on or something.
Yeah.
Okay, thank you.
Thank you.
All right. Okay. We're ready to reconcile. You're going to say happy Friday. Whoa. Long Friday.
Position number one is a total of a $3,000 good bond, reset SAP 727. Position number 2 is a $500 good bond, reset SAP 727. Position number 3, defendant was released, reset further notice. Position number 4 is a $3,000 sign-on bond through the jail, reset further notice. Position number 5 is a $3,000 sign-on bond through the jail, reset further notice. Position number 6 is a total of a $10,000 sign-on bond through the jail, reset further notice. Position number 7 is a $4,000 good bond, reset SAP 727. Position number 8 is a total of a $4,000 cash bond only, reset SAP 727. Position number 9 is a $1,000 good bond, reset SAP 727. Position number 10 is a $3,000 sign-on bond through the jail, reset further notice. Position number 11 will be reset C 715. Position number 12 is a total of a $5,000 good bond, reset SAP 727. Position number 13 is a $3,000 good bond, reset SAP 727. Position number 14 is a $3,000 sign-on bond through the jail, reset further notice. Position number 15 is a $2,000 sign-on bond through the jail, reset further notice. And position number 16 is a $3,000 good bond, reset SAP 727. Any questions?
Nope, think you got it. Nope, we'll see everybody next time.
Good afternoon.
All right, have a good one. All right, bye-bye.
Thank you.
All right, bye-bye.